Hey everyone, Harry here to talk about oral argument this morning in the Supreme Court involving the possible challenge to mifepristone, which is now used in more terminations of pregnancy than any by some margin. In fact, more than half of the terminations in the country. This is a case in which the sort of legal fine points are probably going to come to overshadow the broader context. We're covering it breathlessly in the media because it involves abortion, and it's the first case to involve abortion since the Supreme Court's decision to overrule Roe v. Wade in Dobbs. But I think it's going to come down to the legal doctrine of standing, as I'll explain. Okay, so just a little bit, mifepristone has been used safely for 20 plus years. And twice the FDA has actually relaxed requirements on it, also with very good safety records. So it first had to be prescribed in a doctor's visit. Then it began to be a rollback, and there's rollbacks in 2016 and 2021 that made it easier to obtain a health care sort of professional rather than a doctor could prescribe it, and it could be gotten through the mail, as it often is now. So a lawsuit was brought by a handful of emergency room doctors who are avowed abortion opponents, and that's where they're coming from. I'll get back to the difference between where someone's coming from and whether they have a legally cognizable injury, as the court puts it, shortly. But it had this pretty notorious procedural history. The challenger sued in one, same thing as has happened in other cases with Eileen Cannon, but especially in Texas, which is so vast. There are these pockets of places that if you sue there, you know what judge you're going to get. And they sued knowing they would get one Matthew Kaczmarek, who is himself a real anti-abortion advocate and maybe activist, though he's a judge. And he held that, in fact, the FDA had the challenge, since it is to the FDA's approval of the drug. So there's the argument is it's unsafe, and they have challenged, in particular, the 2016-2021 rollback, saying that those are unsafe and trying to make them a pretty alarmist case out of a few incidents when the overall profile, I think, objectively, healthcare professionals agree is a very safe and widely used drug, and a success story in that sense. Okay, but Kaczmarek, sure enough, strikes it down, and in a very ill-reasoned opinion that I don't think we have to even discuss now, it goes up to the Fifth Circuit, which puts a hold on what he's done for the most part, but not fully, focusing on the latest ones. Then it goes to the Supreme Court, which stays the holding. So right now, mifepristone is as available as it was when the suit started. Justices Thomas and Alito said they would have kept in some of the restrictions while waiting to hear the case. All right. So now it's heard this morning, and a very sort of national focus, but it's really because of the subject matter. And now we have to talk a little bit about standing, which is, it is a pointy-headed doctrine, but a very, very important one. And many of you have probably come across it, lawyers or not. And it's the doctrine that says you can't use the federal courts just because you're against something, even if you're very, very strongly against it. You need to have been personally injured by the government action or whatever action you're challenging. And also, the thing you're challenging has to have caused the injury, and there has to be a way for the court to redress it. Those are the three requirements, but injury, in fact, is the most important. And it's got to be, concrete, not too speculative. What we're trying to get at here is the difference between an old-fashioned lawsuit where, someone hits somebody with a car, but applied to the modern age where statutes are always challenged, but it needs to be someone who's hurt themselves, whose ox is gored, versus statutes where the people bringing them only have, just ideological injuries. They just don't, like it. It's an interesting question because you can find people searching around for a plaintiff that has an injury when really what's going on, what's really driving the lawsuit in the modern era is the ideological opposition. But that's, that's a sort of academic critique of the doctrine. The doctrine's clear. You really have to be injured. And these plaintiffs, man, it is a very weak case for standing. As the Solicitor General said at oral argument, they don't come within 100 miles. All right, they are emergency room doctors. And here's their argument. And remember, an injury, in fact, has to be concrete and not speculative and, not a whole sort of chain of inferences. What they say is they don't, of course, participate in any abortions themselves, but they're emergency room doctors. So it could happen that someone uses mifepristone. It's unsafe. They have complications. They come to the emergency room, and as a result, these emergency docs have to treat them. And even they found some doctor, anti-abortion, in one case who, in order to treat the patient, had to actually perform a form of an abortion. And so that is the claim for injury. Take a step back. You're an emergency room doctor. So whoever comes in the door, you treat. But what if the person comes in the door who has side effects, by the way, which are extremely rare? It's a quite safe drug. It's actually two drugs. You use mifepristone with another drug that you could try on its own, and that's what would happen if mifepristone is struck down. But it's much less safe and more painful for women. But so you come in, and these emergency room doctors are, somehow this sort of tinkers to Evers to chance. Remember what we have to link up for the injury. FDA approves in 2001 or whenever it was, 2016, 2021. Emergency room doctor in 2024 has to treat a woman for injuries. And that's the supposed injury that the emergency room doctors are sustaining. So their lawyers got a really hard time at the Supreme Court. It's true, it was mainly from the progressive side saying we don't see any standing here at all. But it is an extraordinarily weak case for standing, and standing supposedly it always has been until this most recent court, a kind of conservative hobby horse, Justice Scalia famously kind of reinvigorated what had been a bit of a loosey-goosey doctrine, but really emphasized it's a constitutional requirement anchored in Article 3. Federal courts can only hear cases or controversies, and a core meaning of what that is the person who brings the lawsuit really has been injured. And so there was general skepticism, and I think what you're going to find, and it'll be a headline, the Supreme Court actually doesn't strike down what the FDA did. Rather, they say there was no standing. But I wrote about this at the beginning of the term because this case was, on the horizon. To sustain this challenge would be to just completely stretch to the breaking point laws about standing. So in the Parade of Horribles in the United States brief, you have the example of, so anything about kids and how you treat them, teachers could sue because it could happen that a kid acts up because of medicine. We're talking about many linked chains of inferences of things that might or might not happen, and in fact, at best, very rarely happen. So I think, and we're talking about a court, by the way, the Fifth Circuit, that is not just the most conservative, they would vie for that honor with the 11th Circuit, but really wacky, really most likely to just depart from the law. So I think you're going to find a majority of the Supreme Court saying this case shouldn't, we don't have jurisdiction over this case, nor did Kaczmarek, anyone. It shouldn't have come forward. So the whole case is just wiped off the boards because the challengers didn't have standing. If they don't do that, it'll be fair, something of a revolution in standing law. Even if they do that, however, will there be, as I mentioned, two justices weighed in at the stay level to say I'd keep certain things in place from the later enacted regulations from the FDA? Will we see some indications from the conservative wing of, Thomas and Gorsuch and Alito, some things they would have upheld? Gorsuch asked a question in oral argument that basically suggested the problem here isn't exactly injury, but the bad fit of the remedy. Just totally wipe out what the FDA did to the very small injury that if they have it, they have. So shouldn't this be a case in which, rather than completely changing the whole national regime of the drug that's used more than any for to terminate pregnancies, shouldn't there be some, prospect for like the emergency doctors to be, someone's on, I'm just making this up, but always on call. So if there's a patient who's taken mifepristone and develops complications, another doctor treats it, whatever. But Gorsuch was raising the point not of injury, but of redressability would be the legal term. That is, taking this little hook and then using it for to get court to do such a wide ranging action. Okay, so that's the case. Big time focus because it has to do with abortion, but it really, I think, should and will come down to the much more legally fine grained, but important constitutional, basics of when a court can hear a case, doctrine of standing, and the headlines will be that the court reverses the Fifth Circuit, but it'll really be a case about standing that doesn't, unless there's a weird opinion that tells a little about some of the most conservative justices, won't really say anything about where the court is or is going on abortion. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.